Welcome to the Law Bank video on appeals from the Magistrates Court. In the legal system, when a decision is made in court, it's not always final. Sometimes, one of the parties involved may believe that the decision was unfair or incorrect. This is where the appeal process comes in. An appeal allows the case to be reviewed by a higher court to ensure that justice is served. Understanding how appeals work is essential for anyone studying law, especially at the A-level. Before we dive into the specifics, let's cover some key terms you'll need to understand. Appellant. This is the person who is appealing the decision, usually the defendant. Prosecution. The legal party responsible for presenting the case against the defendant in a criminal trial. Conviction. When someone is found guilty of a crime. Sentence. The punishment given to someone who has been convicted of a crime. Acquittal. This happens when a person is found not guilty of the crime they were charged with. Point of law. A specific legal issue that may have been applied incorrectly during the trial. Confirm the acquittal. The court agrees with the original decision to find the person not guilty. Quash or overturn. To quash or overturn a decision means to cancel or reverse it, such as changing a guilty verdict to not guilty or nullifying an acquittal, which could lead to a new trial. Remit. To remit a case means to send it back to the lower court, in this case, the Magistrates Court, for further consideration or a new trial. When a trial concludes in the Magistrates Court, the defense has the right to appeal the conviction and/or the sentence. This is a vital right because it allows for a full review of the case. If the defense decides to appeal, the case is completely reheard by a judge and two magistrates. They will go through the evidence again, listen to all the arguments, and make a new decision. The original conviction could be confirmed, quashed, or overturned, or changed to a lesser offense. If the appeal is against the sentence, the court might leave the sentence as it is, or it could increase it, but only up to the maximum powers of the Magistrates Court. It's important to note that the prosecution, which is the party responsible for proving the defendant's guilt, cannot appeal against the outcome of a case directly from the Magistrates Court. This is because the right to appeal in this situation is reserved for the defendant to protect against potential miscarriages of justice. However, the prosecution does have the ability to challenge legal issues through a different appeal process. Sometimes, the issue isn't about the facts of the case, but about how the law was applied. This is where a case-stated appeal comes into play. In this type of appeal, the defense can argue that there was an error in how the law was interpreted or applied in their case. This appeal is taken to the King's Bench Divisional Court, which has the authority to confirm, change, or overturn the decision. The court can also remit the case, sending it back to the Magistrates Court for a rehearing if needed. Although the prosecution cannot appeal against the outcome directly, they can appeal on a point of law if they believe there has been an error in how the law was applied, particularly in cases where the defendant was acquitted. In such cases, the court may either confirm the acquittal, quash it, or remit the case back to the Magistrates Court for a rehearing. Understanding the appeals process is crucial for anyone interested in law. It provides a safeguard against potential mistakes, ensuring that everyone gets a fair trial. Now that we've covered the basics, we'll leave some space here for a summary diagram that outlines the appeals process step by step. This will help you visualize how it all fits together. On the left, we see appeals on points of fact, which are only available to the defense. These appeals to the Crown Court are a right, meaning the defendant has an automatic right to appeal without needing permission. This is because the law expects the police to present all relevant facts during the initial trial. If they fail to do so, they are not allowed to harass the defendant by reopening the case on factual grounds. This safeguard exists because the police have significant power at the start of the process, and this system ensures they do not have too much power over the defendant. If the defense believes there was a mistake regarding the facts of the case, they can appeal to the Crown Court. Here, the case is reheard by a judge and two magistrates. The possible outcomes include confirming the original conviction, quashing or overturning it, or changing it to a lesser offense. The sentence can also be confirmed or increased, but only within the Magistrates Court's maximum limits. On the right, we have case-stated appeals on points of law, which are more complex. These appeals require permission, meaning the applicant, either the defense or prosecution, must obtain permission to proceed. While the defense can appeal directly to the High Court, King's Bench Division, The normal route of appeal for the defense is through the Crown Court first. Since the prosecution cannot appeal to the Crown Court, they would usually have to appeal directly to the High Court. However, appeals on a point of law are rare because they must involve a legal issue. In most cases, once the Crown Court makes a decision on the appeal, it will not progress any further. The High Court may confirm the original decision, quash or overturn it, or remit the case back to the Magistrates Court for further consideration. Please note that from the 2025 sitting onwards, OCR will expect you to be aware the Queen's Bench Divisional Court is now called the King's Bench Divisional Court following the death of Queen Elizabeth II. However, many textbooks, notes, and mark schemes will still refer to the old name, which would have been correct at the time of writing. Thank you very much for listening. Our next video will deal with appeals from the Crown Court.